Hello, students. I hope all of you are doing well. Exams are quite near the corner now. We don't even have 3 months left for our examination, and it's a high time that we buckle up and you know just take the next gear towards the preparation to speed up, right? And especially when there are a lot of speed breakers that are going to come with all the festivals and all the chuttis and all the holidays, a lot of it. So please ensure that you do not miss your speed, yeah, because destination has to be reached on time. And before that you have to be prepared with everything that is possible, that everything that is in your control, that is under your hand, right? All right, so today's session again, we have come up with the next set of legal updates. So let's very quickly get into that, starting with the very interesting Special Marriage Act. As you would be aware, if you have seen the previous year question paper, you would realize that family law is one of those topics from where examiner hits question, right? So very vulnerable kind of, very one of the favorite kind of topics that examiner can pick up, and that is why we have it today in our session, Special Marriage Act. Why? Because recently there was this challenge. Okay, there was a petition that sort of challenged Special Marriage Act on the ground of violation to right to privacy. Now, why did that happen? So basically, there are provisions in Special Marriage Act which says that if there's a couple, they want to get married under Special Marriage Act, they need to give a notice to the marriage officer 30 days prior to it. Okay, now that registration has to be done, that notice has to be given, and that record is maintained in a marriage notice book. And anyone can have the access to that marriage notice book. Anyone can have access to that notice that is stating that we are going to get married in 30 days, right? Now, since anyone can have a look at it, anyone can go and inspect about the same, everybody has the access to it, it sort of violates the right to privacy, right, of the couple. Not only that, there is this section 7 which says that anyone, I mean a person, can also raise an objection against such notice on certain grounds. Now, what are the grounds? Grounds like living spouse. Suppose there's a out of those couple, there's person A and person B. Out of A and B, there's one person who is already married and their spouse and his or her spouse is still alive. Yeah, so in that case, such marriage can be challenged. Unsoundedness of mind, there can be challenges on basis of that also, stating that one of them is of unsound mind, yeah, or maybe of they have some mental disorder, yeah. So on the basis of all of these ground, any objection can also be raised, and it makes it even more vulnerable, right? Why? Because anyone can go access it, yeah, plus anyone can go and raise objection on it. So basically that is against the right to privacy, and that is what was challenged in the court of law. However, on the sadder side, the court rejected the petition on a very simple term, and that was a legality. Of course, court had to follow it. That was about locus standi, and locus standi basically means that court was challenging the capacity of the person who filed the petition to appear before the court. Yeah, so that was the case. However, we can expect some. We can expect some passage, some perspective, or some discussion on this line in our examination. So please ensure that you read about Special Marriage Act, especially this notice wala area, a bit carefully. These are the section, I've already given you the sections, so I don't think sections are going to be very mandatory for this, but at least be aware of what procedure do we follow, and I've already told you about it in detail. Anyhow, we can expect such challenges to be entertained by the court in future, of course, because it makes a lot of sense, right? Violation of right to privacy, court can take such discussion. So either court will have a detailed discussion on it, and court uh, uh, will be in favor of it or will be in against of it. So what happens, of course we'll get to know about it later on, but since court has had a discussion on it, I mean it's a very interesting area, right? Marriage Act plus right to privacy getting hindered, and that is being challenged in the court. It's a very interesting area, and examiner may these kind of areas and can ask you questions on these. Now, talking about Special Marriage Act, the speciality about it is that it applies to all religion. If you know, in family law, you must have learned that all the religion, they have their own laws for marriage, for adoption, for divorce, for inheritance, all of that. Yeah. But in case of Special Marriage Act, it applies to all religion uniformly. So you must have heard about UCC, Uniform Civil Code. So this Special Marriage Act is a very shorter version of that, chotu sa version of UCC. Now here, they allow people from two different religion to come together and get married, and uh, in such case, no Hindu law, no Muslim law, or any of that personal law would be applicable. If two people get married under Special Marriage Act, in such case, only Special Marriage Act would be applicable in their case. Yeah. Okay, moving on to the next update, and that is again with regard to environment. Of course, we cannot avoid environment this year because since last few years, of course, newspaper has been flooded with the environment related news, but this year it's actually going to an extreme. Yeah, and also because India has become very active towards it. Yeah, getting tigers, getting wildlife, getting afforestation, doing so much for carbon emission, yeah, doing so much for the environment. Of course, India has been a pioneer right now in the world, and since we are taking India is taking so much step, newspaper will have to cover it, and since newspaper is covering it, examiner will have to uh, notice it. It will actually seek the attention of the examiner, and you can expect such question, any, I mean, really good questions under environment, be it from the legal perspective, be it from GK perspective. Yeah, we can of course expect from legal perspective as well, because there are a lot of laws with regard to it that takes an international perspective. Yeah, and international law is under our syllabus, so we have to read about it. Now, there's this new interesting bill, that is Wildlife Protection Amendment Bill. So we have so this bill has been introduced in order to implement uh, an international law. Yeah. So, and that international law is CITES, Convention on International Trade of Endangered Species. So there are two bodies that are established under CITES, that is Management Authority and Scientific Authority. Management Authority basically takes care of licensing, okay, whether such organization, such institute, such body should be given license or not. Scientific authority is mostly about the impact of the environment on such species. Okay, so they are basically on the research side. They research more towards it as to if such trade takes place with regard to these species, how is it going to impact the environment? How is it going to impact such flora and fauna and all of that? Yeah, so that is what scientific authority does. Now, there are four schedules that categorize the wildlife. First schedule talks about mentions the list of those species that need highest level of protection. Second schedule talks about that needs maybe a lesser degree of protection. Third one is about plants, simple, and the fourth ones are those that are mentioned in the appendix of the sites. Yeah, so these are the schedules. You can of course, on sites, maybe you can get a question, or maybe Wildlife Protection Amendment Bill, you can get a question, or Wildlife Act, you can get a question. About management authority, scientific authority, you can get a question. Not only that, you can also get a question on the powers of central government. So this bill is promote is basically proposing to give some extra power to the central government. So what happens now when it comes to forest and wildlife and all of that, state government has an upper hand in that. Yeah, because state land, state property, state forest, all of that, so state usually has an upper hand. This bill tries to empower central government also, so that they can also step in, and they can also, ensure such regulation, I mean the participation in such regulation. So here, uh, what kind of empowerment, what kind of power central government is getting. So basically, central there is a prohibition that has been made with regard to the import, with regard to the trading, with regard to the possession of invasive alien species. Invasive alien species means those species that do not belong to such ecosystem. Alien means outsider, foreign. Yeah, so invasive means that is actually interfering with uh, the ecosystem. So suppose there is a species that doesn't belong to that ecosystem, but that species come to that ecosystem and they start attacking the general species that we have here. Yeah, the natural species that we have in that ecosystem. Now in that case, that should not be allowed, because that will destroy the entire ecosystem. Just imagine. Yeah, and that is why such the import of such species, invasive species, alien species, import or trade or possession of such species are threat to an ecosystem, and hence it would be prohibited. Other than that, to notify conservative reserve, previously state government had the power, and now bill is proposing to give certain power to central government as well. Yeah, so that was about wildlife protection amendment bill. Moving on to office of profit. Yeah, so a lot of you, I mean, a lot of students asked me about this office of profit. What is happening with Hemant Soren? What is the story? What do we need to learn about it? All of that. Uh, of course, it is about the disqualification, yeah, anti-defection, but sorry, disqualification. And here, with regard to, I think, disqualification, we learned about it in one of our previous sessions. So for disqualification you can go through it. Uh, for anti-defection also you can go through it. But talking about the office of profit here, it is not actually like anti-defection. It is not anti-defection. Maybe there are certain confusion among you, because MP MLA disqualification, whenever we talk about it, most of you get this idea that it is related to anti-defection. Yeah, but it is, the story is a bit different here. So what is happening here? There was a news that election commission has sent a report to the governor of Jharkhand about their say, about their report on I mean, their findings on Hemant Soren's case. So Hemant Soren is the chief minister of Jharkhand, and so basically there was this complaint that was filed against him that stated that he is Hemant Soren is allocating mines, okay, to himself through some, maybe, so some we can say some false party. So what happens, maybe suppose there's a person A, okay, he cannot participate in that auction of, say, mining, okay, of that mine. So what will he do? He will appoint person B on his behalf. He will ask that person B that, listen, I cannot participate in that auction, you go to that auction. Yeah, I will give you maybe 10% of it. Yeah, and you bid the highest, go there, I will give the mine, the auction. I mean, I will allot the mine according to the auction to you. And so what happens here? Basically, person A indirectly is taking care of the mine. Yeah, so auction happens. It has to be allotted to. I mean, there are a lot of people who are bidding there, but who will get it? The one who is the authority. So here, Hemant Soren was the authority, and there was this complain that he is the one who is holding the who is holding all the lease of mines. Yeah, when he was holding the portfolio of mines minister in 2021. Yeah. Now, with regard to this, there are Article 102 and Article 191 that talks about the disqualification criteria of any MP and also MLA. So 102 talks about MP, and 191 talks about MLA's disqualification. Now, the question arises, what is office of profit? So one of the ground for disqualification is that any person, any government, or say any MP or MLA. Okay, so the law, the constitution says that any MP or MLA, they should not hold any other government office from where they are seeking certain profit. They are receiving certain benefit. Benefit as in maybe salary, maybe allowances, maybe profit. It can be anything. Yeah. So if any of that is being accessed, any of that is being received, in that case it would amount to office of profit, and that is not allowed under law. That would amount to disqualification. And here what is Hemant Soren, I mean what Hemant Soren was doing, that was the same allegation that he had, right, that he was holding an office already, and he had indirectly in somehow he was receiving certain benefit from the government office. So that's why election commission got into this. And now talking about the authority that takes care of it, that would be election commission. Yeah, disqualification of MP, disqualification of MLA, all of this is taken care of by election commission. We covered election commission in detail in one of our previous session. You can please go and check it out. And election commission, again, very important topic, especially when all of these kind of news, and especially this has been a year wherein we got a lot of news with regard to election commission, so automatically it becomes an important area for your examination. Then appointment of new CJI. Currently we have our CJI as Justice NV Ramana is our Chief Justice of India, but he's the 49th uh, sorry, after that, UU Lalit was he sworn as the 49th Chief Justice. But now the next Chief Justice is going to be our Justice D.Y. Chandrachud. And we discussed about the appointment of Chief Justice also in our previous session, when I think when UU Lalit was getting appointed, then we discussed about it. So you can go through it again. So Justice D.Y. Chandrachud, he is considered to be one of the most progressive uh, Chief Justice of India. So he is the one who is going to be the 50th Chief Justice of India. Apart from that, there are certain facts like who was the first Chief Justice of India, H.J. Kania, who was the longest serving Chief Justice of India. That was this Justice D.Y. Chandrachud's father, and he was Justice Yashwant Chandrachud. Who was the shortest serving Chief Justice? That was Justice Kamal Narayan Singh. And these are just small facts, maybe asked here and there in legal GK, or maybe there can be certain, certain mention of that in the passage, just to make it easier for you. I've given you all of these, and yeah, that was it for today's session. I hope you all found it helpful. Please keep revising, please keep taking mock test and analyzing it, and you have to hit it on the D-Day. Yeah. So that was it for today's session, students. Thank you so much and all the very best. I hope you make the next 2 to 2.5 months very, very productive. Thank you so much.